Except, Mr. Fagan, what you're assuming is bad faith, really, because, and that's not the way we function. What you want is a rule that says not only if it can be brought in or should have been brought under 2255, but even if it couldn't have but might have been, and I don't know how far your conflict articulation is going to go, then it can never be an exceptional circumstance standing alone. Well, nothing standing alone is ever an exceptional circumstance. Neither age nor medical condition standing alone qualifies you for a reduction. Does have to be extraordinary and compelling, and for that you need something more. So I understand in this case the argument that the judge's disquiet standing alone should not permit him to modify a sentence, that it had to have been with something else, and I can accept the argument that the something else wasn't much here, but you want a more absolute rule. And I fear that an absolute rule will be twisted and create its own nightmare, because there is nothing that standing alone is extraordinary and compelling.
Your Honor, that's not the rule that we're asking for. Is the rule I was articulating to Justice Jackson, or at least attempting to articulate to Justice Jackson, which is that attacks on the validity of the conviction or sentence
you're saying,
excluded.
No, what you're trying to say is you can't even consider it. And that's what I'm asking you. Is your rule absolute that way? There are circumstances where it could be one among many factors that lead a court to a sentencing reduction, as it can be one among other factors where the court says, no, I'm not going to do it anyway.
Well, Your Honor, I think first of all, I don't think there would be any kind of nightmare, because this is the way it has worked for the entire history of Section 3582C1A1 until the First Circuit decision in, I think it was 2022. So I don't think there would be anything new. If anything, I think their rule would be very complicated and unworkable, because all of a sudden we would see any of the 5,000 prisoners who...
You haven't seen any of that there.
Your Honor,
I love the scare tactic, but I look for reality, and it just hasn't happened. And what I look at is the amicus who provides us with case after case where courts are taking their responsibility very seriously. They're writing 50-page, 60, 70-page opinions, analyzing cases with extreme care.
And, Your Honor, I think that's exactly the problem, because any of the 5,000 prisoners who file 2255 motions in a year could just keep bringing these same claims or new ones under 3582C1A1 and forcing district courts to respond to what are essentially new habeas.
We have plenty of ways to handle frivolous filings, counsel. We do it all the time.
The question is whether...
quickly.
I'm sorry, Your Honor. I think the question is whether Congress was trying to encourage the recycling or the renewal or the creation of new...
What we do know is that Congress was permitting sentences to be reopened. And in none of the words it's used does it put in any of the limitations that you're proposing. It does not limit this to personal circumstances, and in fact the examples don't. It hasn't limited to only questions of fact and not law, which is what you're suggesting. And it has always included that there might be other reasons, and it's permitted the Sentencing Commission to define those other reasons.
Well, Your Honor, I think there is a very strong principle. I think Prizer and other cases are an example of it, and we have some of the others in our brief, that statutory scheme should be interpreted in a harmonious whole. And I think reasons warranting a sentence reduction points to that harmonious whole.
Except our Heck line of cases make very clear that 1983 and 2255 are not invalid if there's a way to read both where the validity of the sentence and conviction are not challenged. And here, this is not challenging the validity of the conviction or sentence. It's asking for a modification under a separate statutory authorization, but it's not challenging the validity.
But the reason for the reduction is a challenge to the validity. Even something like disquiet is, of course, questioning the validity of the original criminal judgment. And yes, that claim would not be cognizable under Section 2255 because it would be substantively deficient, because it's not even clear you can do an actual innocence claim, and if you could, it would require that no reasonable juror would find that the defendant is not guilty.
And the judge never did that, and under motion after motion, he denied relief, legal relief, invalidating the conviction and the sentence, but he didn't grant that. He did something totally different.
And
Thank
then,
you, Mr. Fagan.
Yeah, sorry, Your Honor, and then what he does do, and this is what we see in this case, is he eventually grants a different statutory mechanism for relief, under the basis being disquiet with the verdict and sentencing disparities that are related to his disquiet with the verdict. And again, that is simply just a recycled and frankly non-cognizable Section 2255 claim. An actual innocence assertion was made on 2255 before, and there's another Section 2255 claim pending in the district court right now that makes the same assertion. I think another way to think about it, in addition to the kind of ace in the hole being a procedurally or substantively deficient attack, we'll need to wait for another day because I'm out of time, Mr. Chief Justice.